Good afternoon, everyone. Welcome to this afternoon's meeting of Planning Committee. I'll remember to read this out straight away now, as opposed to last time. May I remind everyone present this meeting will be broadcast live via the internet and the recording archived for future viewing. Can I move on to any apologies for absence?
Bob Penrose, I think he was coming, but I think he's got a meeting with him.
Bob Penrose, okay. Any others? Okay, thank you. Moving on to minutes of the meeting of the 6th of July. We take those as an accurate report of the meeting. Moved? Seconded, thank you. Moving on to section 3. Receive any declarations of interest. Anyone have anything to declare?
Thank you, Chair. I declare an interest on agenda item 9, planning application 2017/00473 full 30 Porthkerry Road. I'm the architect for the scheme and I will be leaving the room.
Thank you very much, Councillor Parker. Any other interest to declare? Okay, moving on. We have the report of the site inspections prior to the last meeting. Happy with those? Moved? Yeah, thank you. And we have number 5, the delegated building regulation applications. Moved? Thank you. And then the planning applications delegated, number 6, delegated planning applications. Report on those. Something to move them, thank you. Item 7, appeals. I'll just hand over to Marcus.
Thank you, Chair. Yes, there are a couple of decisions on this report. You'll see the first decision, I think we did refer to it at the last meeting, it may have come in then, but land to the rear of Westgate, Cowbridge, which was a appeal lodged against non-determination. So you as councillors weren't actually able to make an actual decision on it. Anyway, it's gone to appeal. We did have a report which suggested reasons for refusal that may have been applied if we'd had chance to refuse it. The inspector has looked at it and has considered on page 16 what he identified what he considers to be the main issues, and he has decided to allow the appeal. The key issues in this 4 members are that in allowing the appeal he hasn't applied the 40% affordable housing requirements and has deemed that viability comes into it and has therefore agreed to a sum of £388,000 being paid in lieu of that, the 40% affordable housing. He has also decided that issues relating to conservation area and this nearby listed buildings are not severely enough affected for the application to be refused. So the application has been allowed. The other decision here, which is of relevance, is an enforcement decision. It was an enforcement notice served on Hendrewennell Fruit Farm, Heatermarsh, Wells and Donnets, and stemmed from a number of complaints the council was receiving about events being held at Hendrewennell. The complaints became very vociferous in the summer of 2015 and ultimately culminated in the enforcement notice being served because the council considered there to be an undue impact upon the nearby residences. The inspector has looked at this and has decided that he does or she does not consider the use to be a change of use. She considers that the use is linked intrinsically with the use of the Hendrewennell as a fruit picking farm, and has taken the view that although there has been an increase in activities there, those could be accommodated within the what's known as the 28-day rule, which is where a change of use can occur on a site for 28 days without the need for planning permission. I have to say your officers are disappointed in this decision because ultimately it does mean that the nearby residents are going to could or may suffer further disturbance and And indeed, in determining this enforcement notice, members may recall our main aim was to try and encourage the developers or the operators to think about an alternative access, not to close them down or stop the operation. That was never the intent of the council. However, as I say, the inspector has decided that the use is lawful and has quashed the enforcement notice. One point of note, because I think the inspector has misinterpreted the reasons for the council's in serving the notice, but the inspector has taken the view that because a highways officer didn't appear at the appeal, he's going to award costs against the council. Because one of the reasons, obviously, we took this action was the impact on the neighbouring properties caused by the volume of traffic. Now, it wasn't necessarily a highway safety issue, it was an issue of the volume of traffic just causing noise and disturbance and concerns to residents, damaging the verges, meaning that they couldn't get to their houses, meaning that they couldn't use the road properly. So that is not necessarily an issue where we would always expect a highway officer to comment, because the highway officer clearly is talking about highway safety. Nevertheless, the inspector has taken the view that it is an issue where the highways officer should have spoken on it and has awarded costs against us on that basis. As I say, very disappointed with that decision. I think that is a complete misinterpretation by the inspector of what the reasons the council took the action, which were very clear in the notice and very clear in the made very clear in the inquiry. And I know that local residents are not very happy because they've written to us on a number of occasions, but unfortunately there's not a great deal we can do now.
Councillor Wilkinson.
Can I ask how much the costs are, and if there's any hope one day we may be able to go back to this?
We will not know what the costs are for some time. They would have to submit them to us in due course. In some cases it can take many months, even 12 months, before they submit their costs to us. So we don't know yet, I'm afraid. In terms of revisiting, when the appellant submits their costs, we will go through a very rigorous process of making sure that those costs are reasonable, are not, they can only relate to the appeal itself, they can't relate to anything else. So we will go through that process, but we don't know what the costs are yet, I'm afraid.
Thank you, Marcus. Are we happy to note that for information? Yeah. Okay, thank you. Moving on to agenda item 8, delegated trees list. Someone to move that, please. Thank you. And now move on to planning applications. First application is 2017/00339/OUT, Bryn Farm. Marcus.
Thank you, Chair. Yes, this is an application submitted in outline with all matters reserved for an agricultural or farm workers dwelling on an existing farm known as Bryn Farm up in Cloudcorch. It has they have submitted a suggested size for the farmhouse, which is approximately 140 square metres, with a footprint of 7 metres by 10 metres, and a height, a suggested height of between 6.5 and 8.5 metres. When considering these types of application, your officers do so having regard, obviously, to the local development plan, but also to national guidance, which is clear in Technical Advice Note 6, dealing with rural developments. And we have assessed this proposal having regard to that. You will note that on page 28 it indicates that the farm itself has a herd of 120 cows and 500 ewes. Further on in the report, it details that on page 32 that the size of the holding is 322 hectares, which is a substantial holding, of which 251 are owned by the actual farmers of the farm. And the other key point to note in this application is that there is an existing farmhouse on the holding, which is occupied by the farmer, but the house is required for the son of the farmer. And the guidance which I referred to, Technical Advice Note 6, did change, I say relatively recently, all the things are relative, but around about 2008, 2010 maybe, and took account of the impact of not having regard to generational issues around farms, and the need to ensure that farming families weren't forced off the land by virtue of either the older farmer having to leave the farmhouse or the younger farmer not having a house to live in. So the applicant has made this application on the basis that they want to encourage the younger people to manage farm businesses and promote diversification on established farms. It's paragraph 4.51 of the technical advice note. You'll see that at the bottom of page 33. So we have assessed this application on that basis, and we have noted that the need on the farm is for an additional 0.5 worker unit. Now this sounds a bit technical as well, but this is an assessment that's made on the size of the holding, what the farmer is farming, the animals the farmer is farming, and so that defines the number of worker units that are applicable to the farm. We've also considered what the farmer is actually farming, so it's both sheep and cattle, and that generates a functional need for someone to be on the farm for at least between 8 to 10 months of the year. So those things have all been assessed, and we've come to the conclusion that the application is acceptable, and we have recommended approval in accordance with Welsh Government guidance. Oh, and one other thing which I've missed off, there are 2 late representations. The first is a letter of support from Pendoyne Community Council. It's a further letter of support. There had already been one letter of response. And secondly, you'll note that on page 29, there is a reference to the letters of the MP and AM, Jane Hutt and Alan Cairns, and unfortunately those appendices were missed off the report, so the appendices are in the late representations for all members to see. They are in support of the applicant in this case.
Thank you, Marcus. Anyone wish to speak? Jonathan.
I'll move the officer's recommendations, Chair, if no one wants to debate.
Seconded. Thank you. All in favour? Unanimous. Thank you very much. Now move on to application 2017/004 73/FUL 30 Porthkerry Road, Roos. Vicky, please.
Thank you, Chair. Again, to draw members' attention to the bundle of papers, we're going to change the name of these from late representations to matters arising after the publication of the report, because we have received some complaints from people that the interpretation of calling them late representations somehow implies that they are after a consultation period or worth less than what they would otherwise be. So we'll bear with us, we'll get used to we've called them late reps for many years, so they're not late reps, they are additional matters for you to have regard to following the publication of the Planning Committee report. Sorry about that long-winded introduction. So in this case, we have had further letters from the occupiers of the neighbours at number 28 Porthkerry Road, dealing with matters addressed in the report. They are objecting to the application. We've also had correspondence from both local ward members, and you'll see in the bundle the officer's response to those, which are largely dealing with procedural matters to do with the application and how it's been advertised and so on. And also a further letter from the occupiers of the neighbouring property at number 32 Porthkerry Road, again raising issues of objection which have largely been dealt with in the committee report. There have been issues raised relating to building control matters, in particular sort of fire safety issues and issues associated with having the kitchen at the first floor level, which are largely unrelated to the planning matters in front of us. They will be dealt with through the building regulations application that will need to follow this application. Going into the description of what the application is in front of us, this is various alterations and extensions to an existing semi-detached dormer bungalow in Roos. We did have a site visit there, so thank you to those members that were there this morning for the site visit, where we were able to have a look at the property in the street and also from the rear garden to have a look at the impacts on the neighbouring properties to either side. The application relates to a 2-storey side extension, which you can see on the elevation plans up on the screen, which includes extending the front roof dormer along to the side where there is an existing flat roof garage at the moment, so that'll replace that, with a very small front projection at ground floor as well. Then at the back of the property, there will be an extension to the existing flat roof dormer, again to extend it to the side where the two-storey side extension is going to be. There's a ground floor extension which goes along the full width of the property, and then above that you'll see there's a gabled two-storey extension closest to the neighbour at number 32, and a flat roof terrace which is better shown. Let me just, sorry, I thought the floor plan was on here, but it's on the plan on page 48 of your officer's report, which shows a flat roof above the existing, above the new ground floor extension with a terrace area above that. Concerns have been raised from neighbours. You'll see from the planning history that we have had previous applications for similar, albeit different proposals, and those are detailed in the report. The last one in 2017, earlier this year, was refused. And you'll see from the plans, again shown on page 49 of the report, that there are some significant differences between the two proposals. Being the previously refused one had a much larger terrace area at the back, and we were concerned about the impacts of privacy from that large terrace area. And there was also a much larger extension, a gable extension to the front of the property, again, which is shown on the elevation plans of, on page 50. So you can see from those the distinction between this current application in front of us. We have had a number of comments and concerns raised by neighbours to do with overbearing impacts and privacy, impacts on their amenity in terms of overshadowing and noise and so on. Those are all detailed in the report and assessed in full. And we've come to the conclusion that the scheme has now been amended to such an extent that it's overcome our previous concerns in terms of the impacts on the neighbours and is now recommended for approval.
Thank you very much. I'll now call on our Miss Louise Godfrey, who is registered to speak against, to take a seat up there, if you wouldn't mind. Thank you for coming down to see us. When you're set, you've got 3 minutes, and I'll let you know when it's end. Okay? Just need to press the button on the microphone to start.
First of all, Mr and Mrs McGowan would like to extend their gratitude to Councillor Gordon Kemp for successfully having this application called in and heard before the members of the Planning Committee. Unfortunately, due to previous commitments, they aren't able to attend today, so they've asked me to speak on their behalf and would be grateful if these comments would be taken into account. As their property physically adjoins the application site, they are at most detriment to any implications that may be arisen by this proposed development. Within the committee report, the reasons why the application has been called in are given, and the McGowans invite the members to look at these carefully, particularly the first one, which states that the proposal would have a harmful effect on the amenities currently enjoyed by Mr and Mrs McGowan. Of the 3 previous planning applications, the McGowans feel that they are essentially the same development that is now being proposed and subject to this report. 2 of these applications were withdrawn by the applicant, whilst the third was refused planning permission in March 2017. As of significance, this current application is the second reason of refusal, which states that the development would result in an elevated and direct level of overlooking towards the rear garden of this neighbour, thereby unacceptably impacting upon the privacy enjoyed by the occupiers, and the McGowans feel that nothing has really changed. The objectors contend that if this current application is approved, the rear extension and patio will undoubtedly result in overlooking of the rear garden of number 32 Porthcurry Road, to the detriment of the current level of amenity presently enjoyed. The objectors also maintain that if the above situation will be further exacerbated given the scale of the particular development, in particular its edge-to-edge design. They feel that if a rear extension is to be approved, it should be scaled back significantly so as to limit any adverse implication on the adjoining dwelling. The objectors would like to ensure that all of the letters, in particularly their second and third, have been received and are on the planning file and being taken into account. This is particularly relevant as in all of their applications, they have requested a consideration for the measure of works to be enforced for controlled hours of operation. And this is due to past issues that they've had with the adjoining neighbour, which have not been addressed in this report. They would like the members of the planning committee to realise that this is not just their home, but their single biggest investment they'll ever make. They would like to reiterate their invitation for the members of the planning committee to do a site visit on their property so that you can see the impact that it has from their perspective prior to making your decision. Thank you.
Thank you very much. I will just ask if there's any members who want to clarify anything you've said there before I just step down. Any members wish to raise any points of clarification? Okay, thank you very much for your time. Take your seat there again. Councillor Gordon Kemp, if you'd like to come round here. As an elected member not on the planning committee, you've got 3 minutes of time as well, when you're ready. Thank you.
Most people will be able to hear me, but not online. Oh, sorry. I'm not going to repeat what has been said by the preceding speaker, because I think she's largely covered what the objections are to this. My request for this, for Officer of Delegation to be removed and this to come to the committee, sets out clearly what the problems are, I think, with the exception of the final item level of local opposition. The neighbours in number 32, I think, are disappointed that the committee didn't take the opportunity this morning of actually looking at this from their side of the boundary, although I think perhaps they do appreciate perhaps that was their misunderstanding of how the procedure would work, and that perhaps they should have requested that to take place. But I think it's very difficult to assess the impact of this upon their property without seeing it from their side of the fence, as it were. This extension, when built, is going to be very, very close, and I'm talking particularly at the rear because there's not so much concern at the front. It's going to be very, very close at 0.3 metres, which is a very small distance. There's reference made in the report to an extension they have on the opposite side of their property, but that is, I think, something like probably about 4 times the distance from the adjoining property, so the impact is that much less. As has been said, they feel really there is little difference between this application and those that have gone before. There is some scaling back, but the impact will still be very, very much the same. Overshadowing their property, a complete intrusion upon their privacy and the ability to enjoy their property. The other thing I would just mention very briefly, because I don't want to go over what's been gone before, but it was mentioned that they have been concerned in the past about work being carried out next door, the timings of that, the noise, and the impact that has upon their family. And I would hope that committee could look at some way, if they are minded to approve this, that they can actually make some recommendations as far as timings of that. I appreciate that this is not the type of development that you would normally have very detailed restrictions on use. That is probably for a totally different type of thing, but I think it would be helpful in this case that that is done. But again, I would simply repeat that this is going to have a very adverse effect upon the occupiers of number 32. It is little different in their view, and I think from having looked at previous plans, there is some scaling back, but I don't think a significant one. In fact, if you read the impact to neighbouring amenity that's set out in the report, the issues are dealt with, and it is a matter simply of opinion as to what the effect of those are going to be. Obviously, the occupiers of 32 would say that the impact is going to be totally different from the implications in the report.
Thank you very much, Councillor Kemp. Any points of clarification on any item Councillor Kemp brought up before I open it up for a debate? Thank you very much. At this juncture, can clearly the clock beeped, so we knew it was the end of the 3 minutes. But can we make sure all the electronic devices are on silent? It's gone off a few times. I don't want that to ruin any debate we're going to have now. Councillor Lloyd, do you start?
Thank you. So I just want to pick up on some of the points, really. I mean, just want to start by saying I'm certainly not against development at number 30, but I do share some of Councillor Kemp's concerns on this application. The history is, I think, important. Planning has been withdrawn twice and refused once before, but I think certainly from the objectives perspective, some of their concerns do appear still to be valid. In terms of the privacy, I mean, what might not be particularly visible from the plans, and again, which is one of the reasons why site visits are important, is that the 2-storey extension does have a window on the first floor, and that window would then afford
the applicants the ability to kind of look back at number 32 onto what I believe is a bedroom. So there certainly is some concerns relating to privacy there. Some of my other concerns are around the loss of light. The report by the officer does acknowledge that there is some shadowing. I think we are talking about perception, by the objector and officers here, but we are acknowledging that there is a loss of light that is clearly detailed in the report. And I think what's important to point out here is that the objector certainly is seeing that this loss of light is of greater importance to them. Councillor Kemp's point about proximity to the party boundary, again, you have to point that out. I do have some concerns about the proximity to the party boundary. It is only 30 centimetres away, whereas the historic extension on number 32 is at the other gable end of the building, and probably is around about somewhere between 1 metre and 1.5 metres away from the other property, from the neighbouring property. So I do share some of the concerns on this application. But as I said, I'm certainly not against development, but I do think that perhaps there is perhaps a more sympathetic way of approaching this application, which could result in a compromise, which would see both the applicant and the objectors arriving at a place where they both feel comfortable. Regardless of what the outcome is here today, Councillor Kemp has talked about a condition about the working hours. I would, if the result is that the application is approved, I would ask that we also consider a condition about perhaps making that first floor window frosted, or having some kind of level of opacity on it, so that it does remove some of those issues around privacy. Yeah, that's what I've got to say on the matter at this point. Thank you.
Vicky.
Thank you, Chair. I just want to address a couple of the issues that have come out through those presentations. In terms of the window, firstly, I just want to clarify, because Councillor Lloyd, I think you said that you felt that the window, and I presume you mean the window, this window here, in the gable, that someone may be able to stand there and look back at the windows of the property next door, which I really don't think is going to be physically possible. I think the issue that members need to consider whether or not it's appropriate is whether somebody stood at that window, which you can see from the floor plans will serve a kitchen, whether somebody stood there, whether their degree of overlooking into the garden would cause more of a privacy issue than what is currently there, and that's the issue that's been brought to our attention by the neighbours. We've obviously assessed that and come to the view that whilst yes, this window moves forward compared to the existing windows in the back of the existing house, the relationship in terms of rear windows overlooking neighbouring gardens is, that's the situation that you have on rear windows at the back of every house that's a semi-detached house. Your windows can look into your neighbouring gardens, and that on its own doesn't, impact to such an extent that we don't allow windows in the rear of properties. It's not, it's not the sort of situation that was described where you're stood in the window and that enables you a new degree of overlooking into a neighbouring window, a bedroom window or anything like that. It's just going to be that they will have a different viewpoint, a closer view to a part of the existing neighbour's garden than they currently have from the rear windows in the back of the property, if that explains it. And I think in the additional representations that we've had tabled, there's reference to the fact that there's a single-storey conservatory at the moment at the back of number 32, which at the moment partially obscures, if you like, views from existing rear back windows to a certain element of their patio area. And by moving the two-storey extension at the back, bringing that window out, that changes that issue really, because they'll be going up to the depth of the existing conservatory. I would still argue that actually there is still going to be a degree of privacy maintained by the relationship. That window is, you know, set in from the cheeks of the gable. It's off the boundary. It's a kitchen window. You can see from the floor plans that there's, you know, worktops in the way. You're not going to be able to stand in that window and peer down and get an unreasonable view into the neighbouring garden. There'll still be the normal amount of privacy that you would normally experience from, you know, boundary walls along the garden and the relationship between rear windows and a neighbouring garden. So we have looked at that matter, and we don't think that this is so harmful that we could refuse it on loss of privacy grounds from that window. The key issue that we were concerned about in terms of privacy and why we refused the previous application was the large terrace area that was proposed in the previous application. And I would argue that what's now being proposed is quite different to that original proposal in two ways. Firstly, we have suggested that the area described as terrace is limited, and it's limited by condition as well, so that it's a much smaller area. You can see it on the floor plans on page 48. It's enclosed by a glass balustrade which defines that area, so that will be the area that's a sitting out area, and in being limited in size obviously means that its impact in terms of its use is more restricted than when it was a much larger external terrace area. But in addition to that, we've required that a screen be provided along the side of the larger flat roof and also coming across in front of about a third of the terrace area. You can see it clearly on the plans, to restrict the views towards number 28 and their garden. And again, that is controlled by condition. In addition, if you can see from the relationship, if you compare the typical section shown on page 48, which shows that whilst it's a ground floor single storey extension in part, it has got a sort of lean-to arrangement with like a parapet wall behind it, so that the lower area is partially screened. Now, I'm not suggesting that that screens from eye height, because quite clearly it's a low level, but it will have that effect of the perception of overlooking, you know, where people will be able to use that terrace area. They will be sat back from the rear elevation. They will be screened by, you know, a tall obscure screen for part of it, and then a lower wall level. So I think the perception of overlooking when you're sat in either of the neighbouring gardens will be reduced by those works, and we've come to the view that actually that goes far enough to address our concerns in terms of the privacy of the neighbours' gardens. The other issue to do with the design was largely to do with the extension at the front, the gabled extension, which has been dramatically reduced and has overcome our concerns in terms of the previous reason for refusal number 1. In terms of the hours of construction, we haven't recommended a condition controlling hours of construction. We do occasionally impose those types of conditions, usually on very major sites or in very sensitive locations where we feel there is a particular risk that above and beyond the norm in terms of construction. It would be unusual for us to limit construction hours on what is essentially a normal household extension. We grant hundreds of these every year without the need for these kind of conditions, not least of which because our environmental health colleagues have powers to control noise nuisance, and they would normally be the body responsible for that. That's not to say if members really feel that there is an argument here that control construction hours is necessary, then you know, I don't have any strong views against imposing that. I'm just explaining why we haven't suggested it as the norm. Our standard condition that relates to the hours of construction that we would normally limit to, I looked it up before we came out of the office, it would normally restrict from Monday to Friday between 7 and 7, and on Saturdays between 7 and 5, and no construction on bank holidays or Sundays. That's the standard wording that's that we have used elsewhere. if members wanted to impose that, then by all means we could word a condition along those lines, or even an informative. But I would say first and foremost it's the Environmental Health Department that should be controlling those sort of issues. The other issue that a couple of times people referred to, number 32, and their own extension, which again for those of us on the site we did have a look at today. The reason that's referred to in the report is because there was some concerns from the neighbours that the two-storey element at the back that's being proposed here would have a boxing in effect, in view of the fact that they've already got their own extension at the other end. And to a certain extent the officer's report has set out, well, you know, it would be rather unfair on the applicants in this case that if they were refused planning permission to build a two-storey extension on their side because their neighbours felt boxed in by their own extension and the new one. So that's the reason for the reference to that extension. You know, we're not trying to suggest that this extension has the same relationship with the neighbour as at the other end. I think that deals with all the matters that came up through that. So.
Thank you. Councillor Lloyd.
I may have missed it, sorry Victoria, but can you just deal with the loss of light and the proximity to the party boundary as well, please?
Sorry, you're right. Yeah, I did skip over that, I'm afraid. Yeah, if I can turn members to the site location plan here on page 59 of the committee report, which has got a north arrow on it. So you can see from this plan that the properties and the rear of these properties are largely south facing. So the amount of impact in terms of loss of sunlight is really going to be limited in that respect. Yes, at certain times of the day and certain times of the year, this the presence of the new two-storey gabled part of the extension could potentially have a very small effect on loss of light, but certainly not to any extent that would justify a refusal on those grounds, because of the orientation of the sun and the properties and where the extension's going. It's not going to cause such an unreasonable loss of light to any of those windows. Okay.
Before I go back to Councillor Lloyd, any other member wish to speak? Councillor Hodges. I will come back to you, Councillor Lloyd.
Yes, thank you, Chairman. It's just to settle my mind, really. In the letter, on Appendix A, the letter there from the neighbours, effectively, it draws our attention to their belief or their thoughts about the possibility of having a separate property within a property in the granny annex and everything like that. Now, I see that there is a condition 3, which seems to cover the against the possibility of that happening. I was just wondering how, if this is passed with these conditions, condition 3, just how safe and definite in law is that if this ever then happened?
Vicky?
Thank you. Yeah, just to confirm, so the application is a householder application. It's not an application to convert the house into 2 separate units. It would require planning permission to do so, and that would be a separate full application that would be required. The condition, to a certain extent, is for clarity's sake, to reaffirm that. But even in the absence of the condition, that is not what's being granted planning permission for. Clearly, the layout plans do show that, to a certain extent, there's a separation of residential accommodation here. You've got 2 kitchens, you've got 2 living rooms. That's not that uncommon for a granny annex type arrangement, and for households that live in this manner. It doesn't mean that the house has been separated into 2 units for planning purposes. There's clearly internal links between all the accommodation. They're not separated in any way, and we're satisfied that it doesn't represent 2 separate planning units.
Okay. Councillor Johnson.
Just for clarification regarding the terrace, so the intention is that the terrace has been scaled back from the previous set of plans and has a 1.8 metre glazed glass balustrade. Is that what it is? So that's 6 foot high. So the only way you would have any overseeing from that position would be if you were standing and looking out from there. Is that correct? You wouldn't be, if you were sat down with a table or lounger, then you wouldn't be overlooking the next door property in any case. Is that correct?
Vicky?
Yeah, I think in assessing that issue, the screen is not going across the entire frontage, so you can't say there will be absolutely no degree of sight from sitting in the terrace to the neighbouring gardens, because there will be to a certain extent. The screen, I hope you can see it clearly on the floor plan. Like I say, it comes about a third of the way across the frontage. But yes, a 1.8 high metre screen is the normal height for a privacy screen, that even if you're standing immediately next to it, eye height is usually lower than that. I think you'd have to be relatively tall to be able to see over that. But certainly the fact that the little terrace area is set back away from there means that any views towards in that direction with that screen will provide an adequate screen between those areas.
I think the rear elevation, the bottom right corner there, the image of the person shows where the glass balustrade is low enough for a person as opposed to the side screening. Councillor Thomas.
Thank you. Overlooking is always a problem whenever planning applications come up, in my experience. Helpfully, the late admissions have sent us photographs showing photographs from property number 32 overlooking the garden of number 30 and the amount of overlooking that there is at the moment. Now, those were some site visit. I mean, we're surprised at the size of the gardens anyway. I think we all commented on how small the gardens were, smaller than we'd expected. The back garden. That was a general feeling, I think, amongst those who were on the site visit. But the overlooking is there at present, and I really don't see that this extension is going to make that sort of more overlooked. If you follow my meaning, but if you look at the photograph that's provided, they're looking at that sort of angle as well. This is the conservatory that the number 32 have built, and the new wall is going to come out to level with that, which will actually cut down their overlooking of number 30, and number 30 won't be able to look back into there because it's sort of level with that.
Thank you, Councillor. Councillor Lloyd.
Just a final comment. Can I just confirm that the glass balustrade that's a condition of the planning? That's the first point. And secondly, whilst I appreciate that conditions around working times are not usual in this instance, it was cited as a key concern for the objector in the public speaker presentation. So I would graciously request that we do consider that in this instance.
There was a form of words offered in terms of condition by Vicky in her reply. Was that enough for you with regard to, it was an informing note with regard to how it should be dealt with, and then obviously the secondary powers that the environmental health officers have, or did you want something in addition to what was suggested?
I think I need some clarification. Sorry, Vicky, I thought that what you were saying was that in circumstances where working hours are restricted, they are restricted to Monday to Friday 7 till 7, Saturday 7 till 5, and nothing on bank holidays or Sundays. Is that what you're saying?
Yeah, those are the hours that we have in a standard condition. In this case, I would say that it would be appropriate to attach an informative, which is not a condition, it's an informative saying those are the normal hours of construction. And if we do receive complaints that construction is being undertaken outside those hours, it should be for environmental health to take it up as a noise nuisance. We have put them on as conditions in the past in other circumstances. And in doing so, we then have powers as a planning authority to enforce against a breach of condition, which are over and above what our environmental health, it's, well, not over and above, just in addition to our environmental health officers' powers. But we are guided against doing that by Welsh Government, unless we have very good reason to do so, because it's a duplication of powers. So we have those sort of conversations about doubling up on NRW's powers or Welsh Water's powers and so on. It's a similar sort of treatment. So I would recommend that you put an informative on, which should be good enough to advise the builder that those are the hours that are reasonable and those are the hours they should be sticking to. And if they do go outside those hours, then they can expect environmental health to be using their powers to look at noise nuisance and so on.
Is committee minded to go with the informative, or would they like a condition place? I'm just going to take this to a vote now. I think we understand the issues around both sets of that and the reasons behind maybe not enforcing it as a condition. All those in favour of an informative, please raise your hands. I think we'll go with informative condition, informative note on that. Move approval, Councillor Thomas. Seconded. All those in favour of going with officer recommendations? Those against? I don't think there are any abstentions to be seen. Okay, that application is approved. Thank you very much. Thank you for your time, Ms. Coffrey. Move on to planning application 2017/00520/FUL, site of proposed new roundabout land at the A48 north of Darren Farm, Cowbridge. Marcus, I believe you're speaking on this.
Thank you, Chair. Yes, this application, and there are late representations, just to point that out to members. There is a comment from the Public Rights of Way officer raising no objection to the proposed scheme. This application follows a previous approval under 2014-1505 for a housing development and new link road on land north of the land at the A48 north of Darren Farm, Cowbridge. Essentially, that application granted consent for a roundabout to be placed on the A48 to access the new housing development and also provide a bypass to get to Lantwick Major. That application included 3 spurs off the roundabout, 2 to go to the A48 either way, and 1 into the housing the link road and housing development to the south. The current application has come about because subsequent to that application, in 2014, the farmer also applied for an additional access off the A48 to access farming activities at his farm, Floynhelig Farm, which is north of the A48. And when the Highways Authority looked at the implications of that subsequent access being granted and the roundabout access, felt that the two would conflict with each other. So, following advice from the Highways Officer, the applicant has now decided to redesign the roundabout and to make it a 4-spur roundabout, so that there is the two A48 accesses come in and go out. You will have an access down to the link road and the housing development, and an access north, which will provide a farm access to the land north of the A48. The key issues around it are that this will actually reduce the amount of hedgerow that will be lost as part of the development, because it means that the access further down the A48, which isn't now going to be provided, will no longer need hedgerow grubbed out, and it's only the hedgerow that's associated with this roundabout needs to be taken out. And the other issue key to members to note is that the applicant has agreed to enter into a unilateral undertaking, which is a legal undertaking, to essentially not implement the other consent, so that we don't end up with a spur off the roundabout and a second access further down the road. So, which would not, I have to say, to give you some comfort in terms of thought process, it wouldn't happen anyway, because to get the roundabout adopted by the Highway Authority, they would have to ensure they don't provide that access in any event. But there is that comfort that the applicant is willing to enter into a unilateral undertaking on that. So that's essentially it. If there are any questions, happy to answer.
Councillor Parker.
Thank you, Chair. I called this application in on behalf of the 3 ward members of Cowbridge so that the many concerns of the residents of Cowbridge have over the large-scale development at Darren Farm could be addressed. The application relates to the amendment of the new highway access as approved in outline 2014-01505 outline on the A48, and a separate access to serve the North and Pentline Estate Farm application 2014/01000 full, which relates to the new highway junction, a new highway junction and track to which Marcus referred to, and that's the one with the unilateral undertaking to remove it. The Council's Highways Department was consulted and advised that the implementation of the previous consent would likely create highway safety hazards, and therefore the Highway Authority would strongly advise that the current proposal has significant safety benefits for there are no highway obstructions would be raised, and they support which is then now supported by the conditions. I support these conditions, but I must say that the condition 6 relating to groundwork and site clearance will serve no purpose, as many of you will know, the hedgerows were removed possibly illegally in March and April of this year. The main benefit to the residents of Cowbridge that this application has is that there should be no need for large vehicles to use the substandard access adjacent to Llwynhelig House. I'm disappointed that no archaeological condition has been included, bearing in mind the roundabout will sit on the old Roman road, and bearing in mind that the archaeological remains discovered on the 5-mile lane have been quite considerable. I would ask if this condition could be included, although I actually think it could be well included within the original outline application, so I'll take Marcus's view on that. I therefore support the officer's recommendation in respect of the junction and roundabout alone, subject to the unilateral undertaking that no other access would be constructed. I'm very satisfied that that is going to be the case. Thank you.
Marcus.
Thank you, Chair. Yes. If I turn to the archaeology first, obviously at page 78, the Glamorgan Gwent Archaeological Trust are our, if you like, experts in this matter who we consult on applications. They have assessed the proposals and indicated it is unlikely that the roundabout will impact on any of these areas. And by that they mean archaeological areas, and the construction of the A48 will have had a significant effect on any potential archaeological remains in the past. Given this and the extensive investigations undertaken on the land to the south in conjunction with the residential development, they do not consider that any further details or conditions are required. So our own archaeological experts have said they don't consider a condition is necessary, and we wouldn't normally apply that condition unless they require it. They've obviously taken the view that the A48 will have, when it was constructed, will have had an impact, but on top of that, there has been some work done already in terms of the housing development site to the south, and they're happy that there's nothing needed more further than needed in this particular development. Turning to the condition 6, which was the condition about the condition 5, I think it was actually, about the no, it wasn't 5. It was 6. Sorry, about the hedgerow planting and hedgerow removal. It's important to remember that although the hedgerow south of the A48 has been removed, hedgerow north where the farm boundary is hasn't. So that condition deals with the part of the hedgerow which hasn't been removed already, and it's important that that is maintained. I appreciate that there were a lot of concerns about what happened to the south, but obviously it is important that that is maintained to the north there.
Yeah, I'm satisfied by that. Thank you.
Councillor Penrose.
Just second, Councillor Parkers.
So that's moved. Anyone else wish to speak before we move to the vote? All those in favour of the application? That's unanimous. Thank you very much. Moving on to application 2017/00500/RG3. This relates to Llansanna and Llanharry Junior and Infant School. Who's speaking on this? Vicky.
Thank you, Chair.
This application is for a relatively simple matter, construction of a single-storey extension at Llansana Church in Wales Primary School. The application for the single-storey extension is to provide for additional toilet facilities and a sort of multi-purpose breakout room for use by the school. It's not increasing the capacity of the school in any way, and that's important to note because a number of the objections that we've received on this are talking about existing issues and problems that are commonly associated with primary schools, and that is to do with traffic and access and inconsiderate parking and all of those issues that happen around most primary schools and secondary schools too, I'm sure. Not to belittle those concerns, but this application really doesn't have any bearing on those because they're not increasing the pupil numbers or anything like that. So, so to a certain extent, they're not that relevant to this planning application. So the application itself is relatively straightforward, a small single-storey extension to the existing school block following the roof pitch and line of the existing roof building. We've considered issues to do with the loss of the area of playground that this would obviously result in, but there's plenty of room remaining to serve the existing school, so we're satisfied that everything's in order and that it's recommended for approval.
Thank you very much. Moved. Seconded. All in favour, please. Thank you. That's unanimous. Thank you very much. Oh, no? Abstain, Bob Penrose. My apologies, sir. With that, thank you very much. Have a great summer and see you all in September.